Welcome back to this week's episode of The Emily Show for Monday. May the 4th be with you. We have two things on the criminal docket today. Both are updates in really heavy cases, but they are updates that I want to cover. They are not cases that I'm covering on stream at this point because, well, they are in LA and we do not have a ton of video from LA courts. Though the last David updates, a lot of you asked if we could go over the court proceedings that we did have on video, and we will do that down the line. But there were so many updates that happened over the past week that I wanted to get into those today. So as we get into those updates, we are going to cover Nick Reiner first. We are going to cover David second. So if you want to opt in or opt out of any of the coverage today, A, I completely understand. B, it is always my goal when covering heavy cases to make sure that you have the information that you need to understand what's happening in a case, to understand the evidence in the case without getting into every single detail, because there are a lot of details that have come out in the David case that are just horrific. And we are not going to get into every single one of those details, but I am going to be overviewing what the prosecution filed this past week, why they filed it, what's happening with the preliminary hearing, what happened with the prelim dates, how everyone got confused about the dates in the first place, and then where we go from here. And for now, I'm going to be keeping updates on the David case to either really quick short form content or updates here on the podcast. The judge has already said that they will not be streaming this case because of the nature of the charges and the victim being a minor. So we will be keeping those updates here, but it's going to be a while before we get to any more substantive hearings in court, I believe. So with that, and with those warnings, thank you for being here. Thank you for being a law nerd. It's time to get into this week's episode of The Emily Show. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. First case we are talking about today is the Nick Reiner case. And yes, both cases that we're talking about today are coming out of the LA District Attorney's Office. They are both in the downtown court in LA. I imagine Nick Reiner and David are probably being housed in the same unit in Men's Central Jail. And the DAs in both of these cases are both part of the same unit at the LA County District Attorney's Office, their major crimes unit. We've talked about the major crimes unit here before. That's a unit that now defense attorney Alan Jackson, that we have covered a few cases with, including the Reiner case for a half a second, was the former head deputy of. It is not a unit I was a member of at the LA County District Attorney's Office when I was a DA there. But we are talking about the LA court system where I practiced. So some of the things that I can actually explain are just from my own experiences working there, which hopefully is helpful. As we are looking at the Reiner case, this case was set over a number of times before arraignment. Remember, at arraignment, it is just notifying the defendant of the charges against them. And then in LA, they use a lot of preliminary hearings more than they use indictments. Some of the jurisdictions we've covered here, it seems that they use indictments almost exclusively and not as much preliminary hearings. The difference between those two, as a quick reminder, is that indictments are done with just the prosecutor, though they are obligated by law to show exculpatory information. Each jurisdiction is different with that. I think the jurisdiction we saw that had the most rules about bringing the defense side of the case into the case was New Mexico, and we talked a lot about that in the Rust case. But a lot of jurisdictions go forward at indictment, and that takes care of the probable cause hearing. LA uses preliminary hearings quite a lot more and much more frequently. They also have a really high volume of cases. Preliminary hearings are also a probable cause determination. I think the last one we watched together was in the Corey Richens case. It was a 2-day evidentiary hearing. The amount of evidence that comes in at those hearings will vary by prosecutor, by case. Sometimes it's largely law enforcement and no civilian witnesses. Sometimes it's a combination. But it's a hearing to show the judge that the charges that are being brought are the proper charges, the defendant's the proper defendant, and an overview, just a probable cause level of the case before the case gets bound over or held over for trial. In Los Angeles, you have from arraignment to preliminary hearing 10 court days. So in the David case last week, You saw a lot of kerfuffling about that being set on a 3 of 10 day. And I realized somebody had asked me about the David case and I sent, oh, it's set 3/10. And they're like, what? And I'm like, oh, wait, no, not March 10th. No, it's the 3 of 10 day, because that's shorthand for me, because I'm used to that 10 days from arraignment, 10 court days. That 3 of 10 date's just going to be like a pre-preliminary hearing or a pre-trial hearing to make sure evidence has been turned over and to make sure that everybody's ready to go forward on the 10 of 10 date, because 10 of 10 is when those preliminary hearings will go forward. That's not exactly what happened in the David case, which we'll get into. But when we saw Nick Reiner's arraignment getting put over, we finally got to an arraignment in the Reiner case. And now we are waiting for that preliminary hearing date. And we have an update because he was back in court on April 29th, 2026, and they put it over for more dates, but it's interesting as to why. Leonard, a quick break from our heavy topic on today's podcast to thank our sponsor, Shopify, who allows us to bring you topics like this without worrying about how they'll be treated on the platform. And they support the Leonard shop. From starting this shop in, the middle of the night at the speed of ADHD and building it myself, to growing it to where we're at now, bringing you another new launch that I am so excited to get into your hands. And one of the things I know that you love, that I love too, is the Shop Pay button. It makes it so easy to check out because you don't need to get out your wallet. You don't need to log in. It's all just handled and secure. Shopify makes it so easy to design your own site with their built-in studio with hundreds and hundreds of ready-to-use templates. So your shop doesn't just look like everybody else's, but also it's really easy to get it up and running, and it matches you and your brand style. They have world-class expertise in inventory and international shipping, plus they can handle your returns, and if you ever get stuck, they have 24/7 customer service. Leonard, it's time to see less carts go abandoned and more sales go with Shopify and their Shop Pay button. Sign up for your $1 per month trial today at shopify.com/Leonard. That's shopify.com/Leonard. Thank you, Shopify, for sponsoring today's episode, and let's get back to the podcast. The article we are looking at is coming to us from the LA Times with a photo from Nick Reiner being in court February 23rd when there were cameras in the courtroom for that arraignment, which we covered together. The headline on this is Nick Reiner murder case delayed until September. Autopsy report still not complete. This comes from James Quelly and Richard Winton. I'm not familiar with Mr. Winton, but I have followed James Q on Twitter for quite a while. He works for the LA Times. His reporting on the goings-on of court in the LA Times, I have always found really reliable. So if you are looking for sources to follow, I'm sure he is on all of the text-based apps that you want to follow, Threads, Blue Sky, whatever is your app. I'm sure he's there, but I have followed along on Twitter and with the LA Times. Their summary of their article says that the murder case against Nick Reiner, who's charged with the killing of his parents' beloved Hollywood icons, Robin and Michelle Reiner, will not proceed until September. The delay was caused in part because prosecutors have been unable to turn over autopsy reports to the defense. The LAPD obtained a court-ordered security hold on the medical examiner documents months ago. We're going to come back to this because this is the same thing that was happening in the Celeste case. And last week, we talked about the tension between the coroner's office, or the OME, the Office of the Medical Examiner, and law enforcement. And the medical examiner had put out more than one comment to the media saying that they do not prefer there being holds on the medical examiner records. They prefer that they are able to be transparent with the public. And again, this is a case where a suspect is already in custody. They need to have a preliminary hearing, and not having the autopsy reports at this point is getting a little bit long because we had a cause of death and manner of death in December, if not early January. The article goes on to say that during a hearing downtown LA Wednesday, that was April 29th, Deputy District Attorney John Chung said prosecutors will have nearly 2 terabytes of discovery to provide to the defense, and said that the autopsy reports in the case had yet to be prepared. That's getting into being quite a long time at this point. They go on to say that Josh Rubenstein, the communications director for the district attorney's office, later confirmed that the reports are not complete. They go on to say it's not clear why the reports had yet to be completed more than 4 months after the killings. Kelly Vale, a spokeswoman for the Los Angeles County Medical Examiner, said both cases remain on, quote, security hold via court order initiated by the LAPD. Rubenstein said either the LAPD or the DA's office will have to move to unseal the autopsies when they are completed. So here's the thing. The hold on the records is not what's holding it up here. The hold on the records is part of the problem, but the autopsy's not complete yet, which is surprising to me because they do have a cause and manner of death. So I'm unsure what is not complete unless it is scientific testing that is significantly backed up. And that's possible if they wanted to do more nuanced scientific testing. I don't know what that would be in this case that would really hold that up. They go on to say that representatives for the LAPD and the LA County Public Defender's Office, which is representing Reiner, did not immediately respond to requests for comments. Both victims were killed with a knife, according to the death certificate. So I don't understand what the delay is in completing the autopsy reports, especially when we've seen that the cause of death and manner of death were determined pretty quickly. So once we get the autopsy reports, I will get them, I will go over them, and I will tell you if I see anything in them that seems to indicate why there was a delay. But that's a question mark that I have. And it's an issue of really frustration, I would imagine, for the defense to not be able to go forward in this case. However, they're going to have other evidence that indicates why Nick Reiner is connected to this. And if the defense thought that pushing to go forward at preliminary hearing at this point would get the case like dismissed and refiled, I'm sure they would. But with the other evidence, they have a cause of death and manner of death. They could, in theory, go forward with preliminary hearing with just that information. So this isn't something we're seeing the defense push on heavily, but it's something I'm sure they're frustrated by. And it's something I'm sure the DA's office is frustrated by, because what are we waiting for? And if the toxicology is truly that backed up, if the scientific reports are that backed up, why are they that backed up? And can't this get completed because somebody is in custody? I mean, there might be other cases, and there probably are, that are pending that no one's in custody on. So can't we just push this into a rush status? But I don't know. It's unusual to me to see that the reports are still not completed. Let's look at those next dates on the Reiner case, and then we're going to shift focus and talk about the David case. And we are looking at the docket right now for California versus Nick Reiner. The preliminary hearing setting date has been set for September 15th, 2026. That means that is a date to pick a date. It's a meeting to schedule a meeting, to make sure that discovery is done, to bring any motions that need to be brought, to argue about discovery. But September 15th as a prelim setting. So Nick Reiner has waived time to get this case out to September 15th. And then on that date, maybe they will set a preliminary hearing date a month, 2, 3, 4 or more out. And when we're looking at the docket, there's no intermediary date on the calendar. That doesn't mean that the DAs and defense attorneys won't be communicating with each other and turning things over, but there's no other date. What else will the DA's office be doing? Well, during this time, they're going to be prepping their preliminary hearing, which also involves prepping towards trial. And at some point, they are going to have to convene a committee to talk about whether this will be a death penalty case or not. That determination doesn't have to be made prior to preliminary hearing, though, and probably won't. So with that, we are going to shift focus to the David case. We are going to take a moment to thank our sponsors. Yes, we have sponsors in our podcast episodes, and really, truly, it helps support the channel when we cover cases that are heavy, that are horrific, and that I'm not going to turn on other forms of advertising on. So a huge thank you to our sponsor. Leonard, a quick moment to thank our sponsor, Lola Blankets. First of all, this is the blanket that everyone in my family fights over, including Fred and George. Not only are Lola blankets literally the softest blanket I've ever used in my life, but they stay beautiful and fluffy and just like new after they're washed. And it's not a wonder that Lola Blankets has created the perfect gift for Mother's Day because it's actually part of their story. The brand was inspired by a mother named Amy and their Lola, who found comfort in her own soft blanket while battling breast cancer and later gave blankets like hers to her children so they would always feel the warmth and love. And in her honor, Lola also runs a program called Blankets for the Brave, where they regularly donate blankets to women living with stage 4 breast cancer and support breast cancer research. The first Lola blanket I ever got was a gift, and it was so perfect. And what I love is with the wide variety of blankets, you can find the Lola blanket that's always going to be on your couch or favorite chair, and not one that you're going to be trying to put away when people are coming over. It's no wonder that Lola Blankets has over 20,000 5-star reviews and thousands of people gifting it, loving it, and talking about it. There's a reason it's called the world's #1 blanket. Lawnard, you're going to love a Lola blanket. And for a limited time, y'all get 40% off select Lola Blankets products with code Lawnard at checkout. Head to lolablankets.com and use code Lawnard at checkout to get 40% off select products. And after you purchase, if they ask how you heard of them, let them know it was the Emily Show. This Mother's Day, wrap mom in the everyday luxury of Lola Blankets. Now, let's get back to the Emily Show. Singer David was also back in court on April 29th. Remember, that was set as a 3 of 10 date. We talked about that a little at the beginning of this episode, and many thought that that might be a preliminary hearing date. You guys know from following me that that was in fact not going to ever be a preliminary hearing date, and the preliminary hearing was set out after that. However, when they went into court, we ended up with a few things that happened. One, the prosecutors filed a preliminary hearing brief that broke down what the evidence will show at preliminary hearing, almost similar to a trial brief with, we expect that the evidence will show this at preliminary hearing, even though it's a probable cause hearing. And part of me just wonders, and this is my own wondering and speculation, is that during the arraignment, the defense made quite a lot of saying, this case hasn't been out in the open and we think that it should be more transparent. And I have to just wonder if the prosecutors were like, well, just so we're all on the same page, here's our preliminary hearing brief. Are they filed in every case? No. Does it help in a case like this where the DA has said that there's like 40 terabytes of information already? Yes, it does. Especially because we learned from the last court appearance that the David case involved wiretapping. Very interested to see on my end if the wiretapping is what led to them choosing to arrest him when they chose to arrest him. And not only that, but there is also going to be information from the Tesla. Those cars can compile quite a substantial amount of info, and downloads from phones, computers, probably also from things like Discord, Twitch, YouTube, Google, and the rest of it. So the prosecutor filed that brief. We're going to look over parts of it today. There is a lot of detail in it. I am not going to get into every single detail, but there are going to be details that we cover that are difficult, that are just truly horrific and tragic. And there's still going to be questions that aren't answered because we're not even to preliminary hearing yet in this case. But when they went into court, the defense was then frustrated, it seems, that the prosecutor had put all this stuff in a preliminary hearing brief. And I can imagine that the prosecutor is like, but you, we're just trying to help narrow it down to be ready for prelim. And the defense had said, we are going to prelim within 10 days. So it makes sense to narrow down the scope of that prelim and say, this is what we're going to show you. It seemed that the defense said, that's too much transparency. We are going to hear more about the images on David's phone that we talked about in the last episode. We are going to hear more about the evidence in this case and Celeste Rivas' parents' contact with law enforcement a little bit as well. I know there's a lot of questions about that. We don't have a lot of answers, and we probably won't. My focus is truly on what was David doing, what connects him to her, what connects him to this crime. What we do know from Celeste's parents is they had called law enforcement at least 11 times when she was missing. And we are going to learn in this brief that law enforcement had been in touch with David. And it seems to me that he was less than truthful with them. But we'll see how that plays out. So what we are going to be taking a look at now is the preliminary hearing document. I've also been looking a lot at the reporting from LA Magazine. They have had reporters in court. There have been others in court day to day. So when there are reporters in court, I am looking for their breakdowns of what happens. But we're just going to go to the document that we have because, well, we don't need the summary of someone else's summary. But also, if this goes to trial, we will talk about whether or not Emily just needs to take a trip to LA for a minute. We are probably 2 years or more out from that, so we can have that conversation. Watch this goes to trial during like the Olympics in LA. Could you imagine? That would be a nightmare for everybody. I think the attorneys would be like, not a chance. Either way, this is not going to be swiftly approaching trial. We'll talk about it when it happens, if that is interesting to you. This was filed by Deputy District Attorney Beth Silverman on April 29th, 2026. We're going to go through the background of the facts. There will be things on screen, some of which I may sanitize a bit, but I will also link the LA Magazine article that has this document in it if you would like to go through and read all of this. Purely your choice. There are things in this that you can't unsee or unknow, so that is my word of caution if you want to go read it for yourself. Background facts. The dismembered body of 14-year-old Celeste R. was discovered in the front trunk of defendant's Tesla Model X on September 8th, 2025. The vehicle had been towed 3 days prior, and then they give the address at 1405 Bluebird Avenue, which was parked approximately 400 feet from defendant's home at 1368 Doheny Place in the Hollywood Hills. These were rental homes. David is not staying there anymore. This is not somewhere where you go real world to see what's going on at the home. I'm sure this has been rented to somebody else by now. Leave the locations be is my warning. They go on to say that surveillance video and other evidence confirmed defendant was the last person to drive the vehicle on July 29th, 2025 before he left Los Angeles on a concert tour. This is information that answers a question that a lot of people, myself included, had, which is, how do they know if he was driving the car? Well, I said Teslas record a lot of video. Teslas record a lot of video, including video of the driver. So knowing that he was the last person to drive the car is one of those answers that kind of clicks into the puzzle that is this case, because there's a lot of possibilities when someone's found in a car. Was he driving the car? Was he out on tour? Had he even been in possession of the car? Did he have somebody else driving it? All of those questions. So David was the last person to drive the vehicle. They're going to have, I imagine, video that connects him back to it, or Teslas can also be started with your phone. However, then you would need to know he's in possession of his phone to show that somebody else didn't take his phone and start the car. On September 8th, 2025, the manager of the tow yard where the Tesla had been impounded noted a strong smell of decay and a presence of flies coming from the vehicle. He notified LAPD, which is the exact right thing to do. Those are all the red flags. Anyone who's a first responder recognizes those red flags immediately and called law enforcement. Law enforcement responded. Law enforcement confirmed their concerns and then located remains in a black cadaver bag inside the vehicle. They go on to note the 2 fingers that had been removed and were not located. That will come up, but it was the victim's ring finger and pinky finger on the left hand. There had been a lot of speculation about whether or not that was the finger with the tattoo that said, shh, that those are not the fingers that were removed, but the ring finger and pinky finger from the left hand were removed and were not recovered. On September 16th, 2025, the Los Angeles County Medical Examiner identified the body from dental records as belonging to the victim, Celeste R. I suspected that this was a dental record case. We understand now that it is confirmed that this was an identification by dental records. It goes on to say that pursuant to their investigation, LAPD robbery homicide determined that the victim and defendant met in January 2022 when the victim was 11 years old. They began to have sexual contact in November of 2023. They say when the victim was just 13 years old and the defendant was 18. Detectives learned that the victim had been reported missing from Riverside County Sheriff's Department by her family, who lived in Lake Elsinore, in February and April of 2024. And that's RCSD telephonically contacted defendant on February 17th, 2024. So at some point, Riverside County sheriffs contact David, who's living in LA County. They contact him on February 17th, 2024, after they identified a phone number in the victim's phone records that belonged to him. So the Riverside County Sheriff's Department is trying to find who might have contact with Celeste R, going through her phone records after she's been reported missing, find David's phone number, call David. David says that during the call, defendant claimed to have spoken to the victim last on February 13th or 14th, 2024, but stated he was unaware she was a minor or that she had been reported missing. We will hold on to that sentiment and see how true that is as we go forward in this case, not necessarily in just what's in the prosecution's document here. Because remember, this is the evidence that the prosecution believes will come forward. Again, spoken from their perspective. But we know that sheriffs contacted David and was like, yo, where is the missing 13, 14-year-old? He was like, I don't know. I didn't know she was a minor. It goes on to say that Riverside County sheriffs advised David that LA sheriff's deputies would be coming to his home. On that day, defendant was living at 804 North Doheny Place in West Hollywood. Riverside County requested that LA County Sheriff's Department conduct a welfare check on defendant's home. LA sheriff's deputies went to the defendant's home at 8:15 at night and informed him that the victim was a 13-year-old runaway. Defendant again claimed he was unaware that she was a minor and they had only met the victim once in person in November 2023. I have so many questions. However, defendant showed deputies a yearbook photo of the victim he had on his cell phone. What, from her junior high school? From her junior high school yearbook? You have a picture of her junior high school yearbook on your phone and you don't think she's a minor? Although he claimed to be unaware where the victim was at the time, she returned home 2 days later. Yeah, how big's the home? And I wonder if her cell phone showed that her location was at that home when the sheriffs were there. If you're the sheriffs, you can knock on his door and you can ask, but you can't go search the entire home at that point. If he's like, nah, she's not here. Despite being informed by law enforcement that the victim was only 13, defendant continued to pursue her. After the victim returned home in February 2024, her parents took her cell phone away. Defendant drove to Lake Elsinore, not close to LA, and paid a junior high school student in the victim's class $1,000 to give victim a cell phone that defendant purchased so they could stay in contact. Pursued is the right word here. What do you do if you have a 13, 14-year-old? You have taken away their phone. You have them going to school, and someone goes to their junior high, pays a classmate to slip them a phone so that you can maintain contact. Control, coercion, those are my thoughts. But you can maintain contact with a junior high school student. It's an absolute nightmare. And I imagine that we will find out that the way they first got in touch when she was 11 was because of the games he was streaming. Because I imagine that's the connect here. David paid another junior high school student $1,000 to give Celeste a cell phone. Throughout 2024, the victim spent a significant amount of time with defendant, including summer weekends at his home in the Hollywood Hills, traveling with him to Las Vegas, London, and Texas to meet his family. I have a lot of questions about this. I don't know how in the world a minor got to London with this defendant, because even if they were traveling private, I would imagine that there was still immigration checks, unless somehow she had a fake passport, which I suppose is a far out possibility, but with money, most things are possible. But how did they get to London? How did a minor get out of the country who had been reported missing? It goes on to say that text exchanges between the victim and defendant contain references to sex, pregnancy, abortion, the use of Plan B emergency contraceptive. There are also explicit photographs documenting and corroborating the sexual activity between the two of them, which I had wondered about last week. I also wonder if we will see charges added related to that, because we could see charges related to that. But last week, when we heard about the amount of images of minors on David's phone, I had wondered if some of those images were also of Celeste, and if that's part of what is corroborating her age in this relationship, and if that's part of why this case will be sealed. That will be evidence that a jury eventually, if this goes to a jury trial, that a jury will need to see to corroborate the charges of continuous and ongoing sexual abuse of a minor. Videos and photos would substantiate the continuing sexual abuse of a minor in this case. They go on to say that in November 2024, defendant and the victim broke up, although they continued to communicate, and text messages suggest that they also continued to have sexual relations. I just have so many questions about the travel, and I'm trying not to get distracted by the travel because there's so much more information in this filing. I have a lot of questions about the travel. I also have questions about her meeting his family. I have so many questions. I also have questions if we will see more charges based on the things that are on his phone, either state or federally. That could happen. I don't know if we'll see that, but yes, additional charges can still be brought. They go on to say that April 23rd, 2025 is the likely date of the victim's death and when all her cell phone activity ceased. We talked about this in the last episode when I said that they were probably using pattern of life cell phone data to ascertain a time of death. And then they are going to talk in more detail about what led up to the April 23rd, 2025 death. The prosecutors say that the night prior, April 22nd, 2025, defendant and the victim engage in a lengthy argument described in detail in their text messages. The messages reveal the victim's jealousy over defendant's relationships with other women, and defendant led her to believe that they had a future together. Right, that's called grooming. She became extremely upset and threatened to disclose damaging information about her relationship with defendant to end his career and destroy his life. We saw discussion of this in charging him with special circumstances murder for pecuniary gain. It goes on to say that defendant's first studio album was due to be released April 25th, 2025. I did not know that. I knew that he had performed at Coachella, and I knew that there were a bunch of like big brand collaborations in the works. We talked about them last episode, including the collaborations with Crocs and others. I didn't realize that that was all corresponding with the album drop. It went on to say he had an emerging multi-million-dollar career already in progress. He also had multiple product endorsements, which were highly profitable. Oh, Emily, just keep reading. At approximately 8:40 p.m. on April 23rd, 2025, defendant sent an Uber to transport the victim from her Lake Elsinore home to his residence in the Hollywood Hills. Just for a little bit of reference, that's like an hour and a half drive, depending on traffic, but it's a little over 75 miles, depending on where in Lake Elsinore and where in Hollywood Hills. But that's like a 75, 80 mile drive. This is not close. But also, if you're parents, what do you do if somebody sends an Uber and your kid walks out of the house? Ugh. They communicated before and during her Uber ride, which dropped her off at the defendant's Hollywood Hills home around 10:10 p.m. At approximately 10:30 p.m., defendant sent text messages to the victim inquiring where she was. The people contend, and again, this is the prosecution's allegation, the people contend this was part of the defendant's premeditated plan to cover up the murder, as she was already dead by this time. So we see a lying in wait allegation that he was lying in wait at the home for purposes of murder, in addition to the murder for pecuniary gain and murder of a witness. The prosecution has stated that the murder of a witness is that she is a witness to his improper continuing sexual abuse of her and potentially other things. And she was saying she was going to bring that forward. And there might be other things on her phone that indicated she was actively pursuing that. So she was a witness to the crimes against her. Yes, technically killing of a victim. However, that gets very confusing because she is a witness of a case against her. That's a pretty long Uber ride, and Uber records would show that she was dropped off and when she was dropped off. So I imagine they're getting that from Uber records. They go on to say, quote, knowing he had to silence the victim before she ruined his music career, as she had threatened, very soon after her arrival at his home, defendant stabbed the victim to death multiple times and stood by while she bled out. They go on to say that at no time did he call law enforcement or 911 to take her to an emergency room to attempt to save her life. They're saying this is not accidental. This is intentional. This was lying in wait. This is a special circumstances murder. They go on to say, despite knowing she was dead and her family was trying to find her, the evidence will show that defendant lied and claimed he didn't know where she was. In fact, defendant drove to Santa Barbara County immediately after the victim died, attempting to dispose of her property and destroy evidence. At approximately 11:30 p.m. on April 23rd, 2025, he drove away from his home as he texted and called the victim's phone, asking where she was. That's not the first time we've seen it. Look, people keep trying it. People keep trying it. Doesn't work. And again, depending where, Hollywood Hills to Santa Barbara is roughly 85 to 90 miles, depending where you're going. And that's also going to take, well, more than an hour and a half, depending on time of day. This was at night, so maybe not as long. And then depending on which way you're going, if you're going up the 101, it's slow for a bit there, especially where they're repairing fire damage. Not quick and still like 90 miles. And the car would log it and the phone would log it, and license plate readers are going to log that travel too. They go on to say that the acts of texting and calling the victim's phone were planned to set up his defense within a very short timeline after the victim's vicious murder. They say that defendant drove his Tesla, and again, it's going to record all of that, north on the 101 freeway to San Marcos Pass Road, SR 154, near Lake Cachuma in Santa Barbara County. He returned home early the following morning on April 24th, 2025, before going to a radio interview for the release of his album that week. So if the Tesla needed to stop and charge, all of that would be logged on the vehicle and probably the Tesla charging network. But to return home and then go to a radio interview is wild. I imagine that the DA's office already has that radio interview downloaded. They go on to say he sent 2 additional texts to the victim's phone that day, which obviously went unanswered because she was already dead. After April 26, 2025, defendant never attempted to contact her again. What, he got bored with his alibi? The DAs are going to then explain what David did to cover up this crime, which is always an opportunity to decide if this is information you want to know or not. The DAs go on to say that the defendant subsequently purchased tools to carry out his plot to dismember and dispose of the victim's body. Again, we saw this happen in the Walsh case, and we saw how that played out at trial. So if you watched the Walsh case with me, you will remember the things that prosecutors brought forward from the Walsh case at Home Depot and Lowe's and the rest of it, and the gift cards. They go on to say that on April 24th, 2025, defendant ordered a shovel from Home Depot that was delivered to his home from Postmates. On May 1st, 2025, he ordered and subsequently Amazon delivered 2 chainsaws to his home. On May 5th, 2025, defendant ordered and Amazon subsequently delivered a body bag, heavy-duty laundry bags, and a blue inflatable pool. We talked last week about where he would order the body bags from. I had seen a number of you in the comments say that he had some music videos that had themes of death and murder and killing, and those could have come from there. The DAs have answered that in this, talking about what he purchased on Amazon. They say that he made these purchases under a fake name, Victoria Mendez. On May 8th, defendant returned to the same area in Santa Barbara County, leaving his home around 11:30 p.m. He returned to the area again on May 31st. This is an isolated site off SR 154 where the victim's identification was subsequently discovered in January 2026. For identification of the victim to be located in January 2026 in this area, law enforcement would have already had tracking information from either phone or vehicle. That is the only way they're finding that out there, in my opinion. I mean, it could be a combination of phone, vehicle tracking, and license plate readers, but they located her information out in an isolated, desolate area that he had returned to at least 3 times. They go on to say that on July 7th, defendant ordered and subsequently Amazon delivered a quote unquote burn cage to his home under the same fake name as part of his plan to incinerate evidence. The prosecutors describe how David used the chainsaws in the inflatable pool and that small blue fragments were found embedded in the victim's remains, which were collected by the LA County Medical Examiner's Department, and the fragments were analyzed by LAPD's Forensic Science Division, the Trace Analysis Unit. We've seen trace analysis in a number of the cases that we've covered. The LAPD Trace Analysis Unit was able to make a physical match of the blue fragments to the blue inflatable pool purchased by defendant in May 2025. They go on to say, in order to distance himself from the victim, he amputated the left ring and pinky finger because her ring finger contained a tattoo of his name. So not the shh tattoo on the pointer finger, but a tattoo of his name from, it sounds like, her left ring finger. They go on to say that those fingers have not been recovered. They say defendant then placed remains into the cadaver bag and some remains into the garbage bag and put them into the front trunk of the vehicle. They say for several weeks or possibly months, defendant left the victim's body to decompose inside the Tesla. He lied to friends, business associates, and others who noticed the strong smell of decay in and around the home and vehicle. What? I wonder if that came from the grand jury. And no one called the police? All of the indicia of you need to call the police seem to be there. And no one calls the police? Lied to friends, business associates, and others who noticed the strong smell in and around the home and vehicle. I really wonder what those conversations went like during grand jury proceedings, because I imagine that was not friendly questioning. I imagine there was a lot of questioning about, and then you did what? Oh, and then he left on his concert tour at the end of July and he parked the Tesla on the street around the corner from his home. It's LA. You don't think your car is going to get towed? You can't just leave a car parked on the street. It's going to get towed. Who was going to move the car? Who was the person that was going to keep moving the car so it didn't get towed? And did they decide not to? They go on to say that LAPD served a search warrant at the defendant's, this was the rental home at 1368 Doheny Place on September 17th after the victim was identified by the LA County Medical Examiner. We had seen reports about that search warrant being served, and then it felt like it was so long from the time that search warrant got served till we even heard that there was a grand jury investigation till this charge happened. They go on to say what was recovered in that search warrant, or part of what was recovered in that search warrant, saying that inside the garage, detectives discovered evidence consistent with the dismemberment of the victim's body in the inflatable pool. Because the inflatable pool contained multiple linear cuts, they had biological samples that they took that tested positive for blood and that were collected within the garage area. They say that DNA analysis from various samples matched the victim's unique genetic profile. So it was not just blood type, but they tested and determined that that blood was in fact the victim's. On December 9th, 2025, the medical examiner ruled the victim's death as homicide caused by 2 penetrating injuries to the torso, stab wounds. On January 17th, 2025, the victim's U.S. passport card was found by a Caltrans worker off SR 154 in Santa Barbara County. Oh, I was wrong about that. Emily, keep reading. Interesting that it was Caltrans out in the area that found a passport card. Emily, what other forms of identification would she have? Well, she wasn't old enough to have a driver's license. So it makes sense that there's a passport card. I just have questions about when she got her passport, how she got a passport. I have a lot of questions about that. But yeah, she wasn't old enough to have a driver's license. So that would be the only form of identification that she had. Though to get a passport for a minor, you need both parents to sign it. You know, Law Nerds, that I record the podcast episodes with the members. So if you are a member, always look out for those notifications. But the members have also pointed out very astutely, including Views Through a Lens, saying, what date was the passport issued? It's a great question. And put it on our list of questions for this case. I also wonder what date the passport was issued. And was it issued after she was involved with David, or after David became involved with her? Because he's the adult in this situation. And getting involved with an 11-year-old when you are 18 is completely inappropriate. This is not one of your siblings' friends. What are we doing? They go on to say what the evidence they believe will be presented at preliminary hearing. So this is what the DAs expect to present at that hearing, which is a bit more graphic than the other things that we have covered. But they are going to bring in the description of photographs depicting the victim both naked and engaged in sexual activity while she was 13. They go on to make a note saying that this evidence constitutes child sexual abuse material. The photographs will not be presented. The law enforcement officers who had to find these things will be the one presenting them. The DA goes on to note that while all possible charges that could be proven were not filed, the CSAM is proof of the ongoing sexual relationship while the victim was 13 and 14. Could the DAs choose to add charges? They could. Could they choose to not add charges and leave this as part of the evidence of the ongoing sexual abuse of a minor? They could, because that is charged here. They go on to say that the text messages will be shown, including text conversations regarding the sexual activity between them and discussions of pregnancy, abortion, use of Plan B, etc. Messages through May 2025 prove that defendant continued to manipulate the victim as she messaged, quote, "All we do is have sex and just hang out, man. I want more than that for myself." These messages were obtained from defendant's iCloud data. Defendant's cell phone activity and communication derived from the defendant's iPhone and Tesla, which demonstrate defendant's activities on April 22nd through the 24th, including the trip to Santa Barbara in the middle of the night after the victim arrived in the Hollywood Hills. Surveillance video of the defendant driving his Tesla on January 29th, 2025 for the last time before parking the vehicle and leaving on tour. DNA evidence developed from the bloodstains collected in defendant's garage, which match victim's DNA. Proof of the Amazon purchases that we've discussed. Proof of the defendant's purchase and delivery from Postmates. Uber records showing the defendant's transaction where he ordered the Uber to pick up the victim from her Lake Elsinore home and transport her to his home. Proof that the defendant's career as a singer-songwriter was lucrative prior to April 23rd, 2025. That goes to the special circumstances of murder for pecuniary gain, which was not losing that career. Defendant had an album release party the night of April 24th, 2025 before embarking on an international tour in late July. He went to Coachella. He brought Celeste to his home as they allege it. They allege that he then killed her, then dumped her information in Santa Barbara. They do not allege where she was during this period of time at this point, and then went to an album release party and a radio interview as if he felt that the problem was solved. They go on to say that they will use as evidence the text message exchange between defendant and victim on April 22nd and 23rd, where the victim threatened to expose the defendant and destroy his career. Conclusion. The brief is filed to assist the court in understanding the scope and relevance of the evidence the prosecution intends to present at preliminary hearing. The prosecution has issued numerous subpoenas. It is prepared to proceed with the preliminary hearing. The defense has had multiple opportunities to request a continuance, but has not done so. Furthermore, California Penal Code 1050, that's the statute that allows you to continue things, requires the defense to provide at least 2 days court notice to request a continuance. In view of the limited scope of the evidence to be presented at preliminary hearing detailed in this brief, there should be no substantial impediment to moving forward with the hearing as scheduled. So, Emily, what's that conclusion mean? It means that the DA said, you wanted your prelim in 10 days. Here's what we're showing at the prelim. We're ready. Are you? And you haven't asked for a continuance. So let's go. Preliminary hearing. And we know that that's not what happened, because when they were in court the next day on May 1st, the defense did in fact ask for a continuance. And the prosecution pushed back on that. Let's look at just a little bit of the reporting from court on that. We are looking at reporting from LA Magazine from what happened in court on April 29th. I feel like I have used April 29th and May 1st interchangeably in this episode. However, I was traveling and time is a construct. So they were in court Wednesday, April 29th. They were supposed to be back in court on May 1st and then weren't. The reporting goes on to say that there was a hearing Wednesday at the downtown courthouse where the defendant was brought in, shackled and in prison clothes. They then say that the preliminary hearing, which was set for May 1st, has been moved to May 26th with a status hearing scheduled for May 12th. The delay drew sharp pushback from the district attorney's office, with prosecutor Beth Silverman arguing that the defense knew this was coming and already had witnesses cancel vacations. Right. Because the defense said the very first day in court, we want our preliminary hearing within 10 days. And the prosecution said, we'll be happy to give it to you. This is how much evidence there is. If you will be ready for prelim, we will be ready for prelim, which means you have to go subpoena all your witnesses and be ready. And then for the defense to be like, no, we're not ready yet. I can see why the prosecutor pushed back and said, you could have done this days ago. Beth Silverman said that the defense knew this was coming and they had already asked witnesses to cancel vacations. The main dispute in court centered on the defense arguing that the prosecution's preliminary hearing brief was one-sided and could potentially taint a future jury, particularly given the high-profile nature of the case. Prosecutors pushed back, saying that it would be highly unusual to seal such a filing. The judge ultimately denied the request, noting that high-profile cases are not uncommon in Los Angeles and that a preliminary hearing brief is, by nature, one-sided. Right? It's the evidence the prosecution's going to show to say that there is probable cause that this defendant did these crimes. Of course it's one-sided. It's the prosecutor's brief, but it's transparent. So in the first hearing, the defense is like, we would like transparency, please. And then in the second hearing, the defense was like, too much transparency. Thank you. We would like this to be sealed. And the defense didn't seal it, which is why we have the document to go over. Because again, the preliminary hearing will be a public hearing. Reporters will be in court reporting on it. Honestly, I rather have the preliminary hearing brief from the DAs than the reporters reading the brief or hearing the information in court and then reporting on it. I would like to take the middle steps out, just from the prosecutor to y'all can see it, versus from what's said in court to how someone interprets that to then how it's reported. It goes on to say, in parentheses, that the court did acknowledge that it read more like a trial brief. Fair, but it's not an inappropriate filing. It seems that the defense was upset by it. They go on to then note that David Burke, B-U-R-K-E, has retained high-profile celebrity defense attorney Blair Burke, B-E-R-K. David is currently being held without bail in Twin Towers, and they go on to note that the case has now been assigned to Judge Olamedo and that both sides are still requesting the case proceed to trial within 60 days. We will see what happens with that, because we know that the preliminary hearing has now been rescheduled. So when will this case be back in court? For the David case, it will be back in court May 12th for a discovery update and a preliminary hearing update, which gives the prosecution then enough time to resubpoena witnesses ahead of the expected May 26, 2026 preliminary hearing date. Will the preliminary hearing go forward on that day? We don't know. Could it still get continued more? Yes, it could. We'll see. If the defense doesn't continue it on May 12th and then tries to continue it after that, I think we'll see the prosecution also put their foot down and say, no, we've again subpoenaed our witnesses. But if the defense does not feel prepared for prelim, we'll see what the judge does. They've now had one continuance. Hopefully the date that they have set is a realistic date for both parties. And that means, what do we expect at a preliminary hearing? Well, once we get to preliminary hearing, I think we will see the evidence presented mostly by law enforcement that we saw in that document, which means the lead detective in the case will be one of the primary witnesses coming in and testifying that based on these search warrant returns, and we now know there have been over 40 search warrants, but based on this search warrant return, we got this information. And based on that return, we got this information. And this went out to scientific testing and really gives an overall summary of the case to the court to establish probable cause. We won't likely see the medical examiner testifying, the scientific examiners testifying, the custodian of records for the Apple iCloud or Google. We won't see those types of witnesses. If there are key civilian witnesses, though, you can expect that they might want to lock their testimony in at preliminary hearing early on in the case. So if there are key civilian witnesses, you might see them testifying as well. We just won't know until we get a little bit closer. This is a very difficult and heavy case. The facts are going to continue, I think, to get worse. I don't know if there's much worse to get, but their cases continue to surprise me because there is a lot that we do not know. I still have questions about the wiretaps. I still have questions about what happened in the time from 2023, 2024 into 2025 when this murder occurred. And I have questions about the investigation from 2025 when law enforcement was identifying David as an individual that was having regular contact with Celeste when she was reported missing as a minor. What happened in those investigations, what conversations were had, and we might see more of that as this case progresses, because there are things I still have questions about. But there is a lot of digital evidence in this case, and I expect that if this case goes to trial, that digital evidence is going to be a massive part of this case, as it is with so many. And honestly, in this case, if the digital evidence is what solved this case for law enforcement, I'm glad for it, because watching and waiting after they identified Celeste's remains and seeing if anyone was going to be investigated and seeing what those online who were familiar with David and his streams had pulled up then, there were questions for months where it was clear that these two were in a physical relationship while she was a minor, that it was clearly discussed online, that there were times she was making comments about it. So I think we will see evidence of the things that indicate that he clearly knew that she was a minor and he was continuing to engage with her. And it seems film and possibly record that will go to that continuous sexual abuse count. It is a really heartbreaking case. My focus is going to be always on what we learn in court, how that lines up with other things that we might have heard, and sticking to what we know from official sources. It's a heartbreaking case. It is a frustrating case. And there are questions I have. And we are going to wait till those things play out in court. I'm not going to be covering it a ton on stream because there are not going to be a lot of court hearings streamed. I will keep those conversations here so you can opt in or opt out, depending on what we're covering, because it is difficult. So don't forget to take care of yourselves. I know a lot of you have kids this age. It's hard. It is. But remember, it is a good time to take a moment and maybe talk about whether your kids have heard of this individual, heard of his Twitch streams, heard of the skins on Fortnite, have heard about this case. It might be an opportunity to have a conversation, not about all the details here, but about how people can meet online, and somebody that they watch on stream or watch singing or watch playing video games is not the person that they need to be engaging with offline. Because adult streamers, when you are a 10, 11, 12-year-old, are just that. They are adult streamers. Don't engage with them. Don't think that they are all of a sudden going to be your friend, or that it'll be super cool if you can play on their same Minecraft server. They are adults, and it's a good time to have those conversations with your kids that might like watching gameplay videos and streamers who are adults, and keeping that boundary. And there are a lot of streamers who do it really, really well. I don't know if there are others, but I worry that there are others that don't, because this is not the first time we've seen concerns about a content creator interacting with minors that are part of their community or their fan base. And thankfully, most of those don't end up here. But unfortunately, it is a time to have a conversation about how horribly wrong things can go. And if this case and just asking those questions opens the door for a conversation that is not always easy to have as a parent, then I hope that coverage of this case helps have those conversations. And I hope that it reminds you as a parent listening to this that you do need to check what your kids are doing online, that you do need to check their phones or not have them have access to phones if that's what's right for you. And it's a reminder to you, you are not being too much. Even if your teens tell you that you are not being too protective, even if your teens think that you are. And even if their friends' parents allow them to do A, B, C, E, F, G, A, that's probably hyperbole from the friend and not actually true. And B, it doesn't matter. Because at the end of the day, we are trying to navigate a world that a lot of us didn't grow up in. And it's not always easy. But I hope that coverage of this case and coverage of the Roblox cases and others are a reminder that when you are concerned, you are correct. And you are right to ask the questions and invite the conversation. And that teenage balance of talking to your kids, but not pushing them away to those that are online looking to say, your parents don't understand you, but I do, is a really delicate balance. Because at the end of the day, our teens, especially our preteens and our teens, need to trust us. When they are younger, we need to trust them that they're not going to just go running out into the street or what have you. As they get older, that starts to shift. They need to trust that they can come to us and talk. I hope that this is a way to start to have or to continue to have that conversation, which is why I'm covering it, because I think it's needed. We don't always have such visible cases of predators online meeting with underage children and luring them into something that they just can't get out of. And it's heartbreaking, but I think that the conversations matter. And that's why we're going to keep having them. So with that, thank you for being here. Thank you for being a law nerd. Thank you for having these conversations with me. Stay tuned in the app. We have a lot of fun things coming for the law nerds this month. And that includes some stuff that you don't want to miss out on. So you're going to need to have the app for that. And we can always keep you in the loop when you can opt in or opt out of cases like this one. So thank you. Take care of yourselves, take care of each other, and I will see you on stream soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.